I'm meeting with Todd Wetsel, a mediator here in the Salt Lake area. And before we go any further, would you give your name and the contact information for your practice for those that would like to contact you?
My name is Todd Wetsel, and my contact information is telephone 801-633-1361. And there's information on my website at innovativedivorcesolutions.com.
innovativedivorcesolutions.com. All one word?
All one word.
All right. So I'm pretty happy to have Todd here because he's a popular guy and he's a hard guy to schedule. I won't bother. Sorry, let's start over again. What I was going to say is I will make no secret of that. So let's. Today I'm meeting with Todd Wetsel, a mediator here in the Salt Lake area. And before we go any further, would you just give them your contact information for those that would like to contact you and schedule a mediation with you?
You bet. My telephone number is 801-633-1361. And I maintain a website with lots of information and tools and my contact information there, and that's innovativedivorcesolutions.com.
All one word then?
All one word,
yeah.
innovativedivorcesolutions.com.
And you can also schedule from the website itself.
I have a scheduling tool there that's pretty cool. You just can click it on and check out my calendar, grab a date. It sends me an email saying I have a date, sends you a confirming email, and then we can discuss later where we'll meet.
Yeah, so it's pretty handy because you can pick the date and time that work best for you, and he'll let you know what's open.
Right.
So tell me a little bit about why mediation and what's your background in that?
My background was as a practicing attorney. I graduated from law school in 1990 and sort of evolved into the family law practice in a business firm where I sort of was given all the clients of the firm that were going through family law problems, and I actually loved it. And did that for about 15 years. And frankly, I got a little bit burned out. And I always felt like I had a knack for helping people settle their cases. I enjoyed trying cases, but I felt like I had a knack for settling cases. And so I eventually started to gradually evolve into doing mediation.
Okay.
And at some point I realized I could do this full time and make a real good living and help people and sleep at night for once without the stress of a law practice. And so I've got a pretty good gig going. I love it. Very blessed.
Yeah, he's a difficult man to schedule. I can't say that of everybody that we've spoken to, some people starting out or some people that just aren't as popular, but yeah, you're a difficult guy to schedule.
Appreciate that.
And without trying to make you sound immodest, why do you suppose that is?
I charge a reasonable rate. I don't have any overhead, so I'm able to feed my family and make a good living and not charge exorbitant hourly rates. And I come in, I get cases settled, and I move on to the next one. I typically do 2 a day. I'll start one at 9 in the morning. Unless the attorneys or the client specifically tell me they need me for a full day, I'll come in and we'll work hard for 3 or 4 hours. I'll get paid. I'll go on to the next case. It usually starts at 1:30 or 2. I'll work hard for 3 or 4 hours and get another case settled and go home at the end of the day.
Okay. Let's talk a little bit. What would you, if you could talk to people that are contemplating mediation or preparing to do that, or not preparing as the case may be, what breaks your heart when you see a case that you know can and should settle but hasn't? What stops that from happening?
I think it's the expectations, and frankly I put a lot of it on the attorneys. I think the attorneys have an obligation to be very realistic about what the expectations of their clients' goals are, and they should lay out in advance the range that a certain issue how it should resolve itself. If it's a money issue, the client should have a reasonable expectation as to what the range that money issue will settle on. If it's a parenting issue, I think the clients need to be educated as to what a reasonable expectation should be for what a parenting schedule might look like or a custody arrangement. So when they come to mediation, they're in the frame of mind that they can see that as the discussion or dialogue starts to work towards that reasonable range, that they can be ready to accept it and say yes.
Mm-hmm.
But if they come to the mediation with such unrealistic expectations and they've not been truly educated as to what reasonableness looks like, it's pretty hard for a mediator to convince them to change their mind, especially if their attorney isn't pulling them aside and saying, hey, the mediator makes a good point. You probably ought to be in this range here. But if the attorneys aren't willing to say that to the clients, either privately or openly in the mediation, it's very difficult to get the cases settled, even if you can sense that the clients want to settle the case.
You get the impression then that the attorneys are just too afraid to tell their clients they've got a bad case? Or that their case, not so much a bad case, but that their expectations are way too high, and they're hoping the mediator will be the bearer of bad news? Do you ever have that happen?
I don't think so.
Okay.
I think the attorneys feel like it is their obligation, which it is, to be zealous advocates.
Mm-hmm.
And I think that some attorneys have a difficult time having that dual role as a counselor, which is also what their obligation is, a counselor at law, to counsel people and discuss what their options are and to talk about what reasonableness looks like. And I think that sometimes the lawyers want to make sure that the clients believe that they're being zealously represented, and sometimes it's hard to say, okay, let me give you some objective feedback when the lawyer's been in sort of this zealous advocacy role for so long in that relationship.
That's a difficult.
Does that make any sense?
It does, and as I said, that's a difficult position to be in, though, because how do you go from telling a client, I'm going to do the best I can to get you the best outcome, even if you're trying to say within reason, the best outcome within reason, and then go to mediation and then kind of turn on a dime and tell them, now you've got to be in more of a compromise mindset.
I think it's the obligation of the attorneys to put them in that frame of mind. The attorney should say, look, I'm going to do everything I can to help you accomplish your goals, but in my professional experience, this is what a reasonable outcome looks like. Here's your expectations over here. I'm suggesting that a reasonable outcome might look like this, and mediation is probably the forum where that reasonable outcome is going to happen. And if not, then we'll just go to court and you can hear it from the judge.
Now, mediators don't get to take positions as far as deciding a case.
No.
But what's your philosophy? Every mediator is a little different. Do you evaluate the case, in your opinion, when you're talking to the people together in the room? Do you do it when you're meeting separately with them in what's known as a caucus, if you've watched a couple other of these videos? Or do you feel that it's not your place to evaluate the case based upon your understanding of it?
I do my very best at the initial stages of the mediation to try to just be an active listener and to gather as much information as I can. And I find myself in most cases eventually expressing an opinion. And in some areas, in some mediators' minds, that may or may not be
Right.
necessary or appropriate.
There are many who will say that they, and for good reasons, not because there's anything wrong with these mediators, but there's a lot of mediators in the camp that say, I must maintain my neutrality at all times, and that even if I had an opinion, I won't express it, and I won't let that affect the way I conduct the mediation.
Frankly, I don't roll that way. I can't help myself. I feel like I'm there to help and to do everything I can to help. And when there's two attorneys there, I feel okay about that, because they can always say, well, the mediator said what he said, but let me just make sure that you understand this is what I think is your attorney.
What do you say to people that will tell you that creates the impression of favoritism or bias?
I don't think it does. We just have to be able to talk to people directly about what reasonableness looks like.
Let me give you an example
Okay.
of why people would say that.
Okay.
So you tell somebody, all right, because of your work schedule, you've got one parent who's been a stay-at-home parent for the children's entire lives, and there are 4 of them. And then you are a jet pilot
Right.
whose schedule is never the same, and
Right.
you're always working the equivalent of 40 hours a week, and yet
Right.
you ask for 50-50
Right.
joint physical custody. And then that person says, well, I can tell that you're against me because you won't endorse my plan and you won't find ways to make it work. So what do you say to that person?
That's objective feedback. If I say to that hypothetical pilot, and that's not an uncommon fact
No,
pattern.
it's not. That's why he laughs, and that's why I use it.
It's not a crazy fact pattern. There's a lot of people in that situation who are wonderful, decent parents. I just try to create an atmosphere where they feel like they're getting objective feedback from someone that's just there to help them. And I can also say that I've sat in on hundreds of mediations, and I've been involved in hundreds of cases as an attorney, and you're just not, in the context of this family law system that we have, going to get 50-50 arrangement without mutual agreement by both sides. And it's based on what we hear from the custody evaluators that we work with. It's based on what the attorneys are telling me who are still going into court and getting rulings from judges. and it's based on my years of experience.
Speaking of custody evaluators, what are some wasteful practices that you see occurring in mediation? Did you catch that? In mediation, though. And what are some things that you see that are popular or that people tend to want to do that you like or don't like?
Are you specifically asking about custody evaluations?
No, what I was saying is that the custody evaluations are, of course, an extraordinary waste of time and money, but in most cases. But what are some wasteful practices you see in mediation, whether it be people that schedule them for too long or too short, where, like, yes, they've shown up, but nothing got done? Are you one of those people who likes to get a position statement in advance? Do you like to be given a copy of pleadings, or do you like to come in without any preconceptions and discover the facts, as you were mentioning, in the course of the mediation? What are some of the things that you think are good practices and bad practices that waste time and money, or that make it so that a mediation is more or less productive?
A lot of times, I see that people aren't coming to mediation prepared, and you have to be able to have in advance exchanged information and documents. Mediation isn't the place to be calling your MasterCard company and getting the last 2 years of credit card statements so that you can show your spouse how we racked up $10,000 in debt.
Another fact pattern that's not that unusual.
Yeah, so
I mean, it doesn't happen in every case, but there are people
we're
that really
sitting there
will.
and we're like, well, how do we go back 3 years and answer some of these legitimate questions about debt? Well, how about if we get online right now and locate your bank records? Well, we can do that, and then we do that. But we're waiting around for an hour.
Right, and who are you paying during that hour?
And everybody's getting paid to wait.
Yeah, you've got both lawyers and the mediator and everybody else, and you're burning daylight. And since you're the kind of person that will do more than one mediation in a day,
right?
Not always, but that's
right.
You may end up finding yourselves having burned 2 hours doing nothing but trying to find something out. Then you've got to take the time to process it,
right?
And then find yourself with 30 minutes left to discuss.
The other thing that people do occasionally is they'll have perceptions of what assets in their marriage are worth, and in their mind they'll be thinking, well, I believe my house is worth this much, or I believe that my antique Mustang that I inherited from my grandpa is worth this much, and those new set of tires from Les Schwab didn't really improve the value, and so they have these opinions of value. But if they could come to mediation with a letter from the Mustang guru that says, okay, this is what this vintage Mustang is going to sell for in the Mustang world, or a real estate appraiser's appraisal, or a market analysis.
And folks, it's almost always less than you think. Every now and then you might be pleasantly surprised. But I've been selling off some of my office equipment to move to a smaller office.
It's always less than what you think.
And I'm kind of surprised by how I mean, let's face it, the value is what the market will pay, not what I want people to pay.
So if you're thinking, okay, well, I want to come to mediation and resolve my divorce case, and the main issue is our house, right? And people think, well, I don't want to spend $400 for an appraisal. Well, what's the difference between $400 for an appraisal and spending an extra $600 in the mediation involved in a lengthy negotiation over what we think the house might be worth?
Which will
$600 in attorney fees and mediator time.
Which will usually end up in an agreement to have an appraisal.
That's right.
Conducted. So
Exactly.
You've really taken your $400 appraisal and turned it into a $1,000 appraisal. Yeah, that's a good point. In fact, you just gave me an idea that it would probably be useful, and tell me what you think about this, to actually sit down with a client for about an hour in kind of a mock mediation situation, to give them a feeling for what's to happen. Hey, what do you want to do with the house? Well, I'd like the house to be sold, and with my half of the equity, I'll go put a down payment on a new house.
Right.
How much equity is in your house? I haven't the slightest idea.
That's right.
How long have you had this house? Year and a half. There's probably not much equity,
Right.
or even if there is, and here's another. If there's $5,000 equity in the house, there is no equity in the house.
Exactly.
That would get eaten up in selling costs or refinance costs.
Or you could pick up the phone and call the other attorney and say, hey, we have mediation on the calendar in a month. Why don't we mutually agree on one appraiser so that we can have an appraisal in front of us when we meet to negotiate in 30 days?
Mm-hmm.
And then everybody has skin in the game because everybody participated in the
right.
selection process for the appraisal.
But give the client an opportunity to say, all right, jet pilot who wants 50-50 custody, how would that work? Huh?
Right.
Well, how is it going to work? We can't just ask for it without a proposal.
Exactly.
And a lot of times you'll find yourself saying, okay, I know what I wanted. But when I had to articulate it, I realized, okay, I can't even think of a way to make that work, so what can I make work?
Exactly. Another thing that happens in mediation, as long as while we're talking about sort of the do's and don'ts, and that's kind of how this conversation has evolved, is sometimes I get the impression that the attorneys and the clients are discussing things sort of for the first time.
He's being diplomatic.
And
It
so
happens far too often.
And so
And
you're
he knows this. There are many times when you can tell that the client hasn't been made aware of what mediation is. They have a vague idea, and they haven't prepared.
Right.
And
or
so,
what reasonable expectations of the issues in their case look like. And so the client is having to absorb sometimes some fairly shocking information about reality for the first time.
can you give us a couple of frequent examples you'll see?
Well, the example of the house is a good example, where they find out that there's $5,000 equity in their home, and the client's learning for the first time that they're not going to get anything out of the family home as far as cash.
Right. No stake. They were
That's
counting
right.
on to get their new
So
life
they
going.
could have come to the mediation knowing in advance that, look, if there's less than $10,000 of equity in your home that you want to share in, you're probably not going to actually receive any money, because in reality you're probably more like even if you do have a small amount of equity.
A couple of thoughts that come to mind. Sometimes people have never had their lawyers sit down with them and tell them what child support would be.
Right.
Because that's more or less just a mathematical formula in the state of Utah, and it's easy to figure out.
Right.
And then the client is confronted with how much one's going to pay or how little
Right.
one's going to receive. Same thing with alimony.
And alimony is a big one, and that's another one that we could put on our list of difficult mediation topics. And that's one where I'm glad we brought up alimony came up in this conversation, because I'm not sure what your experience has been, but I see a lot of cases where you get the impression that the potential payer of alimony, and let's face it, in society it's more often than not the husband, hasn't truly been told the facts of life as far as what to expect.
Yeah, meaning what the basis for alimony is. A lot of people don't know. I mean, and I won't keep you in suspense. It's essentially, although there are other factors the court can consider, one's need for alimony, and then if you get past that hurdle, does the person that would be paying it have the ability to pay?
Right.
And people that have the ability to pay oftentimes will feel that it shouldn't happen. I'm not the one that filed for divorce, so I don't see why I should have to pay it, or things like that. But if they haven't been confronted, by the way, that's not a reason. And so if they haven't confronted this, that can be
Right.
a real splash of cold water.
Well, that hypothetical airline pilot that you brought up, he's making $100,000 a year.
Used to be, at least.
Yeah, and his wife has been a stay-at-home mom for the last 20 years, but she got her bachelor's degree back in 1980, right? And so she could potentially make, this is the argument that you're hearing, right?
Right.
And so she could potentially make $20 an hour because she got a bachelor's degree at some unknown college 20 years ago or 30 years ago. Well, that hypothetical airline pilot needs to be told before we come to mediation that you're probably going to end up having to pay a little bit of transitional alimony to get her back into the workforce.
At
Those
least.
are conversations that need to happen before the mediation, so that you're already prepared when you go in, so you're not in the process of, it's hard to be involved in a negotiation where you're just absorbing new information that your attorney's telling you or that the mediator's trying to tell you for the first time. It's very difficult to be in a spirit of negotiation and compromise when you're just learning things for the first time. They're going to have a profound impact on what your life's going to look like after the divorce.
So true. How about the pacing of mediation? How long, on average, do you think a mediation must last for people to make that informed decision? Assuming that they do understand the stakes, how long do you think it should go?
Most cases that I work on last between 3 and 4 hours. Now, I'm told by other attorneys that I handle mediations much quicker than many. And I frankly don't have any explanation for it. I think when I was practicing law, I was so busy as an attorney, and sometimes frantically busy, that I sort of developed this approach to just getting in and solving problems, because I had people waiting in line to deal with. And so it never occurred to me to just sort of, just take your time it was always just like, let's just get this problem solved. These people are paying a lot of money, and let's move on. I feel that when I come into mediation, I just roll up my sleeves and start working as hard as I can, and work as fast as I can. I'm told that there are mediators that like to kind of be thoughtful about the pace, and maybe we need to sit it out for a few minutes and let people just sort of ponder and think, and I'm going back and forth and working as hard as I can, and no one's ever complained that it went too fast. Most people are excited to get their checkbook out and write it out for 4 hours at $100 an hour instead of 9 or 10.
That's true. Now, do you bill at $100 an hour, or do you bill at $200 an hour?
I charge $100 an hour, and the parties usually split that in half. I've had 2 recent cases where the parties mediated all day long, and we were in the 9th, 10th hour of the mediation. This has happened, I can think of 2 times just in recent memory, and this helps explain why I think that there's a limit to what we can do during the day. So the case lasts 7, 8, 9 hours. Both parties have made major concessions.
Okay.
And so you're there and you're getting ready to start preparing final documents, which we do in mediation, that they can sign. And then they start talking about some of the smaller issues, because you have to eventually deal with the smaller things. Now that all the big things are resolved.
All loose ends need to be tied up.
All loose ends need to be taken care of. But what ends up happening is, because both sides have made so many major compromises, and they're so like, oh, I can't believe I gave this up, or I caved into that, then now they start to try to get some gains back. They try to score some wins. But the only place to score these wins are over silly little things like the vacuum.
That's an interesting point. I had never looked at it that way, but that's exactly right. And I didn't realize the reason that may be motivating people.
Because they're looking for a win.
Yeah, I've made a lot of, they owe me.
That's right.
I deserve that vacuum.
Right.
I don't even want that vacuum.
I don't necessarily need the vacuum, but I'm going to get a win somewhere because I've ended up doing this and this and this that I didn't want to do. But what's happened recently, and I've observed this phenomenon, like I said, a couple of times, is they're so tired and they're so worn out that in 2 different cases, I've had people, in one case, the poor woman, and I felt really bad for her, she stood up, she threw her credit card down on the table and said, "Pay the mediator, I'm leaving, I'll get my credit card from you later," and she left. And the case didn't resolve. And so I tried something different the next time when I was in the 7th, 8th hour of a mediation. And I got to the point where I said to the people, the parties, we have all these things agreed to. Let's do this, this, and this, and let's come back and finish this up in a month.
Oh.
Okay?
Well, that's interesting. You're not afraid to take a break, because some mediators will say,
even if we have to work all night.
I'm afraid that this mediation's going to break down if we don't get something on paper.
That's right.
And get somebody to sign.
We need this, this, and this to finish up this, this, and this. And so why don't we get our calendars out and let's pick a date in about 30 days. And you're going to do this, and you're going to do this, and we're going to come back and we'll wrap this up.
And let me guess, the reason is that person saying, I wanted to make some gains, then has the benefit of cooling off.
That's right.
And saying, well, I still would like to make those gains, but now I realize that it's not worth scotching this deal over a vacuum I don't even need.
And the amazing thing about it is in the times that I've actually done this, when I've revisited, or when I've come back to the mediation several days or weeks later, it's almost like the people are completely different. They've calmed down, and it's like I get another opportunity to just wrap things up. We do the paperwork, and we're out of there in a couple of hours.
They get a chance to look back on how far they've come.
That's exactly right. And they've also gotten a bill for their attorney.
Yes.
And they realized how expensive that day was. And do they really want to come back and repeat another day like that and get yet another bill from their attorney?
Well, I appreciate that. Thanks for shedding some light on some areas that we haven't discussed in the past in other interviews.
Well, I hope I haven't been too candid, but
I don't think so. And I think that it's important because you make the theme I think that's run through this is be prepared, and that doesn't mean that you have to go in feeling like this is going to be a discouraging experience.
No, no.
Being prepared to settle, there's a difference between being prepared to compromise and being prepared to settle. If you feel like you came out compromising yourself to death, you probably didn't make the most of your mediation.
And another thing too, and I actually I'm going to give you credit for this, because I read something that you wrote about mediation recently that you posted on your Facebook page. And you presented the idea that mediation needs to be looked at as an option, not something that's being rammed down your throat. And I've tried, and again, I give you credit for this, I've tried to tell people in mediations recently to look at mediation as one of several options to resolve their divorce case. You have many options, right? And mediation is just one of them. I happen to think it's the best option. But you as the client need to be always thinking in the back of your mind, this is a voluntary process, no one can force me to agree to anything, and if my attorney and I conclude I can get a better deal and I can afford to pay my attorney, and it's worth the wait and the expense and the delay to go to this other option, which is the courtroom, to accomplish your goals. And I think it's a great way to put people at ease and just to help them understand that they're in control of the process. It's voluntary, and they can walk out at any time if they think that there's another approach that they can take to get their case settled, which would be the courtroom.
And let's end on that note too, because you may have heard about, and if you haven't, in Utah, you're required to go to mediation in most instances before you can go to trial. Now, that does not mean that you should be eager to go to trial, nor does it mean that you must settle in mediation.
Right.
Now, sometimes I've seen some mediators or even some lawyers that have tried to give the impression that, you've got a duty to meet here in mediation and settle, and everybody will be disappointed in you. But you do have that choice, and it's really a question of what works best for me. Let's face it, sometimes mediation is the choice, not because it's perfectly fair, but because you've got to cut your losses, and mediation's a great place to put an end to the expense and the worry and all the time that you've spent on it.
Right.
But it's mandatory to try, but not mandatory to reach an agreement, although 90% of cases do settle.
Right, exactly.
Thanks so much for being here.
Okay.
And in finishing, please give your name one more time and contact information
yes.
for those that would like to reach you to have you handle their mediation.
Todd Wetsel, 801-633-1361, or visit my website at innovativedivorcesolutions.com.
Thanks very much.